Varo? Tá me ouvindo, Varo? Alô, alô, alô. Tá me ouvindo, Varo?
Peraí.
Beleza, tô te ouvindo.
Peraí.
Eu já te ouvi.
Agora tô, velho.
Tá me ouvindo? Tranquilo?
Agora sim.
Massa.
Peraí, deixa eu ver aqui.
Eu vou tentar share aqui a presentation, só para ver se está funcionando, beleza?
Tá, a Carolyn...
Já está entrando aí.
Já, mas eu não vou aceitá-la ainda não, peraí.
Tá. Deixa eu só share a presentation
Dá o
aqui.
share aí, ó.
Só para você confirmar que está dando para ver.
Já tô vendo.
Beleza, então eu vou dar um stop aqui.
Tá.
Tá?
Tá,
Beleza.
vou aceitar aqui ela, vai que ela quer falar alguma coisa.
Tá legal. Hey, Carolyn.
Hey, Marcio, how are you?
Good, doing good. And you?
Pretty good.
Yeah, I have Gustavo also on the bridge.
Hi, Gustavo, how are you?
I'm good, what about you?
Pretty good. Happy evening.
Yeah, thank you.
Yep.
It is evening for me.
Yeah, he's in Florida.
So later evening. Yeah, we're about 6 o'clock almost here, so it's not quite dark here.
No, not yet, but pretty soon, right?
Pretty soon. That's right.
Yes. Alessandra is here as well. I don't know if you can see her.
Hello, how are you? You're a little blurry, but I can see you.
It's blurry. It's the effect that I put on my computer here.
Yeah.
I think you're gonna join from a different room, right? What do you, maybe? Well, she is going to join regardless.
Okay.
Carolyn, I'm going to be flipping the presentation slide by slide, so feel free to tell me when to move to the next one. And like we discussed, we'll stop at the end of every section, and then you're going to pause and ask if anyone has any questions, right? I think that's how we discussed yesterday, right?
Yes.
Yeah. Okay. So we still have 7 minutes.
Okay.
Yeah, we told them to join us.
I wanted to check in to make sure there was no technical problems.
Oh, yes, definitely. Yeah. We already tested, and sharing is not a problem. I'm going to share again just so you see here.
Okay, perfect.
Yeah, so I can share, and then I'm going to be flipping the slides.
Okay.
But for now, let's just wait, folks. Sorry? Oh, yeah, I'll forward you the invite. Let me forward the invite to Alessandra. Yeah, so let's give them a few more minutes.
Okay, sure. It's only 5:54 here, so.
Yeah. Okay. Gustavo.
Yep.
I'm going to ping folks on a WhatsApp channel saying that the bridge is open, so they can join if they want.
Perfect.
Yeah, we have a WhatsApp group just to talk about investments and trader ideas.
Very good.
Yeah.
And again, thank you so much for setting this all up. I think it'll be good.
My pleasure. Yeah, no, hopefully. I think we're all excited with your presence here. Yeah.
Very good.
Let me add Amador. Hey, Amador.
Hey, guys.
Hey, how are you?
Good. I'm on my way home.
Okay. So mute yourself, please. Okay, I just sent a message to the group saying that the bridge is open.
Can you, Mercio, can you mute everyone? Do you have this option or no?
Yes, I have. Awesome. Yeah, in case folks forget to mute themselves. Okay. But Gustavo, I cannot unmute you.
Yeah, like, so when people will talk, they will need to unmute.
Yeah. Yep. I can mute everyone, but not unmute anyone. But that's fine. They can unmute themselves.
Yeah.
Yeah. Alessandra also joined. Thanks, Alessandra.
Hello.
Hello.
Hi, Carolyn.
Oh, you're on mute, Carolyn. There is a mic icon on the top of the bar menu.
How's that now?
It's
Oh, I
working,
can
yeah.
hear you.
Yeah.
Okay. Happy leap year day.
Yes.
Almost a weekend.
Yes.
And everybody's 3 minutes early, right? Because it's supposed to start at
Yes.
6.
Correct.
Okay.
Yes.
Okay.
But I just notify folks on the WhatsApp group that the bridge is open.
Okay.
And after 6, probably we'll give another 3 minutes. So maybe 6:03, 6:04, we start the presentation. So we give folks also a few minutes because Brazilians are known to not be very punctual.
That's all right.
Karen, I know you sent me a PDF document with the tax information, but I only added a few bullet points on, I created one slide for tax and I had a few bullet points. If
Perfect.
folks need more information, like we discussed, I can forward the PDF to them after the call.
Right. It was a bit much. I just didn't, it was hard to condense it enough.
Yes. I know there is a lot of information on the tax, right? Yeah.
Yes. Yes.
Okay, 1 minute. So Gustavo, everyone that pops up, we need to allow to join, or after 6, they are going to be automatically accepted? Gustavo?
Usually they automatically join.
After 6,
Yeah.
is automatically join.
Okay, great. Thank you. Thanks, Amadou. Thanks, Gustavo. And by the way, Gustavo, you are recording this workshop, correct?
It's recording us.
Yeah. So Karen, are you okay with that?
It's fine.
Okay. Thank you.
Yeah, thanks for recording. My wife couldn't make it now because she's on a plane right now for business travel. But yeah, she has interest on the subject as well.
So, okay, I see that the other Gustavo just joined, Gustavo Santos. Thanks, Gustavo.
Hey, thanks for having us.
Of course. So when you say us, is Gloria with you?
No, she doesn't even know what I'm here.
That's fine. Hey, Eduardo.
Hello, hello.
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 So we're just going to wait a few more minutes before we get started. Let's give folks a few more minutes for them to join.
Hey, Carolyn, if you have a lot of content, you know, you can tell us if you need to start right now, or since this is recorded, I think people can catch up in the very beginning.
Sure.
Or-
I think the 2 hours will be sufficient, or if it's not quite 2 hours, we'll have more time for questions at the end. So I think we have enough time.
Okay.
Sounds good.
Let's wait until 6:03, and then, you know, as folks join, then they'll, you know, see what we're discussing, and they can follow the later with the recording session.
Very good.
Okay. Okay. So 6:03.
All right.
Okay. So good evening, everyone, and thanks for joining. And I'll let Carolyn introduce herself, but I would like to just share with you that Carolyn did our will and trust last month, and Alessandra and I are very pleased with how she handled the entire process. Thank you very much, Carolyn. Also, I would like to thank you for taking time out of your busy schedule to be with us today. Thanks again. Okay, appreciate that. And regarding the presentation, I would like just to talk about what I discussed with Carolyn. She's going to go over every single slide, and what we would like to ask you is to wait until the end of each section. She's going to pause and ask if there is or there are any questions, and then she's going to address the questions, and then she's going to move to the next section. So that's how we plan this workshop. So if you guys are okay with that, let's get started. And Carolyn, I don't know if you have anything else that we would like to discuss before.
No, I'll just introduce myself. My name is Carolyn Powell. I am an attorney in Everett in Snohomish County, Washington. I've been practicing law since 1996, and I started out doing family law, later moved into estate planning and probates and guardianships. And I also take cases through MetLife and AROG as well. And I'm very pleased to be here and doing the presentation with you all. So I'm going to go discuss each slide, and then you know, if there's any questions, you can let Marcio know, and then we could answer those as we go through, so we don't have a backlog of questions at the end. So I'm going to start by talking about trusts and the benefits of them. And then we're going to move into the differences between trust and wills. And if we have time, we'll go into a bit of the tax questions that often come up, and you may have some yourself. So I guess let's get started. So do you want to start with the difference between living trust and wills, or start with trusts?
Max, you may want to change, you may want to flip the way you're presenting, because we can see the meeting notes and everything.
Okay,
and not the major screen.
Yeah, so I'm sharing the wrong screen. Sorry for that.
That's all right.
Okay, so let's try again. Hopefully this time is going to work. Is it
Okay.
sharing the correct one now?
Yeah, I think
it
now
keeps
that's the
bouncing
one.
up. You had it initially, and then it's
So
keeps
should
moving.
we go with the definition first and then
Yeah,
the
let's
difference?
start with the
Okay.
definition and the
Okay.
benefits. A trust is an agreement under which money or other assets are held and managed by a trustee for the benefit of beneficiaries. Different types of trust can be created to accomplish different goals, and oftentimes people talk about revocable trust versus irrevocable trust, and they also have testamentary trusts that are built into a will. So we'll go through all of these. Benefits of a trust. They avoid probate for assets that are held in the trust. They're not considered part of your estate, and they're held for as long as you want, depending on the parameters you set within the trust. You can provide for minor children in the trust, one under the age of 18. I can hear some background.
Eduardo. Hey, Mano, can you mute yourself?
Thank you. It can provide for minor children, because if you have any beneficiaries under the age of 18, they cannot have assets in their own name. And so it can be held in trust to be used for their health, education, maintenance, and support until they become 18. If you don't want them to receive it when they're 18, you can change the parameters of the trust. Oftentimes, my clients use the age of 25. And all the assets are held in trust for them until then. It gets them through the education years. Oftentimes people who have children or other family members with special needs, they can have them in the trust for their lifetimes. So you can be very flexible with the length of the trusts. You do avoid paying federal estate tax on the assets in an irrevocable trust, but assets that are in a revocable trust, meaning that you can change the trust, you can add assets, take them out, and even terminate the trust. Those are still considered your assets. And so those don't avoid federal estate tax, but it depends on what kind of trust you have. And we'll go over that in more detail later. You can also use a trust to contribute to charities. You can use it to distribute real property. This is particularly helpful if you have property in numerous states within our country. If they're all held in trust, you don't have to do a separate probate in every state where you have property. It's very useful. And a lot of people have numerous like investment properties, or they have a vacation home in a different state. And so it's very helpful to keep them all under the umbrella of the trust. You can also keep property separate. Washington State, we are a community property state. So anything you earn or acquired during the marriage is considered community, other than gifts and inheritance. And if you have property that you've inherited or had in your family that you want to keep separate from that of your wife, you can do that within the trust as well, or your husband or your wife. You can also set up the trust to provide for yourself or your spouse if you become incapacitated. Oftentimes with a revocable living trust, if it's for a husband and wife, they're both the trustees initially of their trust, and they're the first stage of beneficiary of their trust. And if either of them becomes incapacitated, then a successor trustee could step in, and while the grantors are alive, the assets are used for their care, and then when they pass on, it goes to their beneficiaries. So you can be very flexible with how you create a trust. It also decreases the possibility of a legal challenge to the way you want your property distributed. If you create a will, there is a chance that your beneficiaries to contest the validity of the will. And what that means is they could say that you maybe were incapacitated, or there was undue influence when you created the will. But with a trust, it's less likely to happen because the trust is usually created way before you pass away. So there's not as likely a chance of it being contested. And you can also establish a means of controlling or administering the property with how you want the trust assets to be distributed either during your lifetime or after your death. You can say, for instance, you leave certain property to grandchildren for their education, and it can only be used for education until a certain age. And then after that age, they might get it outright, or it may go on to different beneficiaries. So you can be very creative with that. And you can meet any other social or commercial goals if you want to hold certain assets in trust for charity and other assets for family members. You can do that as well. Any questions so far? Or we can move on to the next slide, Mercio.
Any questions, guys? Guess no questions. So
Very
now
good.
let's.
So far, good. Okay. Most of my clients who draft a trust also have a will. So it's not that you have to have one or the other. They're not mutually exclusive. Some main differences between a living trust and a will. All right, a will doesn't become effective until after the testator, the person that created the will, dies, while a trust goes into effect immediately after it's signed. A will might need to go into probate after a testator dies, while a trust does not go into probate. Assets held in trust are not part of the estate of the decedent. In Washington State, if a testator left his or her estate to a surviving spouse, for example, because we are a community property state, the will does not need to be probated. And also, estates with assets under $100,000 do not need to be probated in Washington State. You can do that with what's called a small estate affidavit. So a will is a set of instructions for after death, and a living trust is an account that is funded by a person's assets while they're alive, and they can fund it at any time after it's executed. They can either do it right away, or sometimes they put assets in as they accumulate them over their lifetimes. So those are the main differences. Any questions about that? Okay, then we can move on to the next slide.
Okay.
So the different language is used. A trust has a settlor and a grantor, and then the trustor creates a trust agreement. Trust property is put into the trust to be managed by a trustee. I often describe trust as like a third-party bank account. You create the account, you set it up, and then you can fund it. If it's not funded, it just is empty. It doesn't have any power. So it's important to fund your trust and make sure that if you were to put a house into the trust and then you sold the house and bought a new house, make sure you actually put the new house into the trust. If you have bank accounts and brokerage accounts and investments that you want to place into the name of the trust, you have to actively do that. It doesn't just happen automatically when a trust is created. That might sound very obvious, but oftentimes when I do probates and my clients mention that the decedent had a trust, I look at it and sometimes there's nothing in the trust. It's an empty trust, which means you can just ignore it because it has there's no assets to be transferred at the time. The trustee is the person that you choose to manage, administer, and distribute the trust assets. They could be appointed by the court if you don't have someone listed, or you can designate them in the trust. I often recommend that you list some successor trustees as well, just in case the person you designate initially is unable or unwilling to act in that capacity. You can also have multiple trustees for different parts of a trust estate. For example, you might want to appoint a certain person to manage assets for children and have a different person manage assets for business assets. You can do that, or for broker accounts. The beneficiary receives benefits of the trust, and the beneficiary can be a person, it can be a corporation, it can be an association, a charity, or an animal. I often create pet trusts. I don't necessarily do standalone pet trusts. They're often included as part of a will, because if you have animals that you have as part of your family, if something were to happen to you, you want to make sure that they're cared for. So for example, we could do a pet trust that you put, say, $10,000 or $5,000 into it for their care. and their medical care, health, food and lodging until you can rehome them, or maybe you just give that amount of funds to the person that's going to care for them permanently. You can do that as well. Trust property. You can put any asset into a trust other than, say, personal property, because it's really hard to transfer ownership of personal items, but you can do stocks, real estate, cash, a business, or insurance can be put into a trust. So the trust agreement is basically a contract expressing the understanding between the trustor and the trustee who's going to manage the trust. And then how that trust property is going to be held and invested, used, and then the duration of the trust. You can set it's going to last for maybe the lifetime of the grantor, and then when they die, everything's going to be distributed to everyone except minors, perhaps. And then once those children of age, then they get their share outright. Any questions so far?
Yeah, Amador has a question.
Yes.
All right.
What is probate?
Probate is the process of court administration of a will. And when somebody dies with a will, actually, or without a will, if they have assets that are in their name alone, that are not in a trust, and they need to be transferred to another person, probate may have to be opened. So if there is a single person who dies and they own a home, and they might have some bank accounts and some broker accounts, and they don't list beneficiary designations of any of those accounts, and the house is in their name, you'd have to go to court with the will, file the will, and get an order appointing an executor of their will to administer it. And that executor has the court's authority to transfer assets. So they can sell real estate and then put it into a trust account to be used for the benefit of the beneficiaries of the will. They have the authority to administer the estate completely, and they have to pay all the debts of the estate, and then they could liquidate everything. So whether or not you have a will isn't the deciding factor. It's how your assets are held. Oftentimes people die without a will, and then the person's estate is distributed based on intestacy law of the state where they died, where they resided. So it can get a little complicated, but probate is a court administration of a will. It doesn't have any impact on assets held in a trust. I hope that answered your question, or maybe too much answer.
No, thank you.
I have a question too.
Okay, go ahead.
So I was thinking about tax benefit, right? If I create a trust and you put like trust property, and let's suppose there's the stocks, and I want to transfer that to my daughter and my son. Is it better to do like through a trust, or is it better to wait until they are in a age that I think that they should get them, and I would just transfer to them? Or is there any benefit of doing the trust on that?
Well, if you put assets into a trust, and maybe you do a revocable living trust, so for your lifetime, you're the creator of the trust, you're the settlor, you're the first tier beneficiary of the trust, and you're the first, you get to handle the assets in the trust. If it's revocable, you can transfer assets into the trust and take it out of the trust, use it for your lifetime. And then when you pass away, that revocable trust becomes irrevocable for your children. And the trustee that you appoint as your successor trustee will then distribute the trust to your kids as you specify in the trust. So the benefit of that is it avoids probate for the trust. One of the benefits of that is that you don't have, it's not part of the public record. No one can see that. It's a little more private than a will, because you don't have the court's involvement with that. If you had an irrevocable trust that you set up where you can't change it, then that is set up automatically. A lot of my clients say, I want to put funds into an irrevocable trust for my children's education. So I'm going to put like $200,000 in a trust for my daughter, and I'm going to set it up now, but she can't use it until she goes to college. And then once she's done with college, she might have anything that's left over if there's anything left. And so you can set up a separate trustor to manage that for her. Sometimes people use a professional trustor. And therefore, if something were to happen to you, that money is there for her and there's nothing that needs to be done other than by the trustor that you've already appointed. So there are different ways of setting up trusts. But by doing that now, you save your trustee or the executor of your estate from having to create that later. Because when you fund it now, it's already there, it's done. So did that answer your question?
It did. I was thinking more about if there is any tax benefit. So you explained the process, which is great.
Yeah. If you have a revocable trust, the assets in that trust are still part of your estate. And a federal estate tax starts at 13.16 million. So if you have less than that in your whole estate, there's no estate tax. Washington State, the state tax threshold is 2.193 million. So if you have less than that in your estate, there's no estate tax on that. If you have an irrevocable trust, when you transfer assets into that trust, it is taxed at that time. So when it's in the trust for your family, there's no tax on them. But it really depends on what assets you have and when you put them into a trust and what type of trust you have. But there can be tax benefits to that as well. Particularly if you have a large estate and you put them into a trust, an irrevocable trust, and the assets aren't taxed all at once. They're only taxed when your beneficiary has a withdrawal from the trust. And so the trustee is taxed with managing that for your beneficiaries. But I can't give you a specific answer because it really depends on what type of assets you have, how much you have, and when the assets are withdrawn from the trust. But rather than if you have let's say you have an estate that's $15 million, and if you pass away, your estate will have to pay tax on anything over the 13.61%. So there's a big tax hit right away. But if you had your assets in a trust, say a revocable trust, whenever you put a separate asset into the trust, you pay a tax on that transfer at the time, which is probably at a lesser rate than what you have when you die. And so your assets are not taxable to your beneficiaries until they may have to pay capital gains later if there's any increase in value. But it can be a great tax advantage at that time. So I know we're kind of, yeah.
No, thank you. I have another question. You just try to make it a little bit more interactive here. Is there like cases in which the trust might not align with the will? And if the person dies, how does that eventually play out?
If there's assets in a trust, it is not considered part of the estate of the decedent, because when they pass away, that becomes irrevocable for the beneficiaries. A will handle all the assets that are not held in trust.
Gotcha.
And so, and I'll even take this a step further. If you have beneficiary designations on some of your accounts, sometimes people have life insurance and broker accounts and IRAs, and they say and they sign a contract with their plan administrator. Upon my death, I give this to my kids equally. Those are not estate assets, and nor are they held in trust. They go directly to the beneficiary when you die. So it depends on how the assets are held. But trust assets are considered to be separate than the estate assets, because they've already been transferred. All right, I think we might be ready for the next slide.
Yeah, thanks, Eduardo. Thanks, Carolyn. Let's move to the next slide.
Okay. So types of trusts, living trusts versus testamentary trust. We kind of touched on this a little bit. A living trust is created during your lifetime, and it's not, the property held in the trust is not subject to probate. It's not considered part of your estate that would be probated as assets under your will would be. In Washington State, assets held in trust don't need to be disclosed for the court record. And so if you want something to remain confidential, it will be. You may not want all your beneficiaries to know what each of them are receiving. You can have, sometimes people set up separate trusts for separate beneficiaries, and so they're all completely private. You can do that. And it allows a trustor to designate a trustee to provide professional management of the trust. You can have a professional trust department of a bank, and sometimes they have different companies that just do trusts alone. Oftentimes, different broker businesses, they have trusts as well. Different corporations, Fidelity, Schwab, they have their own trust department that you could use to manage the trust for you. And so they would handle all the tax issues, et cetera, for you. We talked about this a little as well. Trust can be revocable or irrevocable, depending on how you want to do it. And again, revocable trusts are set up by you now, and you're the first tier trustee, you're the first tier beneficiary, and you can put property and take it out as however you want during your lifetimes, and it becomes irrevocable when you pass away. An irrevocable trust is something that you set up to be irrevocable right when you create the trust and you transfer assets into that trust, which cannot then be taken out by you. The trustee has control and will manage them as per the instructions that you've set out in your trust. Testamentary trusts, again, are trusts created, actually, they're created in a will, and then they're funded after the death of the trustor. So you might say, okay, in my will, I want everything to go to my children equally. If any of my children are under the age of 18 or 21 or 25, then I want it to be held in trust for them until they're of a certain age. And while it's held in trust, it's going to be used for their health, education, maintenance, and support. And once they reach a certain age, they get the remainder of the trust assets outright. So that's also very flexible, because with a testamentary trust, you don't have to worry about funding it now. It's all going to be funded upon your death, but the trust is created in your will. And so the day you execute your will, that trust is created. Any questions about any of that?
We have a question in the chat.
Okay.
So let me read the question. It's from Luciano. What is the cost and time, effort, commitment of going through probate?
Probate, it usually costs at least $5,000 to go through a probate process. There are court fees. There's a one-time court fee. For instance, in Washington State, it's a $240 filing fee with the court, and then you have $5 for each letter's testamentary, giving you the court's authority to administer a trust, or the estate, excuse me. And then you have the attorney fees that you need to pay them, and they will help you manage the court proceeding, all the procedural steps that you need to go through when you open probate for an estate. For instance, they will publish notice to creditors in a newspaper, and all creditors in Washington State wouldn't have 4 months to file a claim, or they lose the right to do so. You would have to liquidate assets. You would have to maybe sell real estate and vehicles and transfer personal items to the beneficiaries. You would have to pay the final 1040 tax return for the decedent, and any estate tax if your estate is over the tax threshold of $2.193 million for Washington State. And if you have over $13.61 million in your estate, you'd also have to do a federal tax return for that. And then once all the debts are paid and taxes are paid, you'd then divide up all the assets among the beneficiaries, and they'd receive their distributions. So it could take, a probate generally can take anywhere from 4 months to over a year. I've had probates that lasted a couple of years because they had some real estate. Sometimes it's commercial property that took a little while to sell, or maybe there was a fire and the decedent passed away in a fire, and we had to get the insurance company involved, and the house had to be repaired enough to sell. But in Washington State, probates are fairly streamlined, and the attorneys have to take a reasonable fee, unlike certain states such as California, where they might take a percentage of the estate value. So every state has a little bit different probate processes for that.
Thank you.
Did that answer your question?
Well, Luciano has another question. Luciano,
Okay.
are you having audio issues? I can go ahead and ask the next question. Yes, audio issues, he just said here. Okay, so let's just assume that you answer his question.
Okay.
Yeah,
Okay.
you did. He just confirmed that you did.
Okay.
So the next question, he has microphone issues. Who can be trustors and what kind of oversight is placed on them to guarantee they won't go rogue?
Okay. Every state has a trust statute, and when a trustee is appointed, they have the fiduciary duty, the obligation of using the trust assets for the beneficiaries, and they have to provide an inventory of the trust and an accounting of all trust assets whenever a beneficiary requests one. If they take the money and run, then they are liable for those assets. Oftentimes, if you're going to appoint a trustee, you want to appoint somebody who's very detail oriented and financially savvy. That's why people often, if they don't think that their family members are able to manage a trust, they often would appoint a trust department of a bank or another corporation to manage the trust for them. There are fees involved, but then you know everything is done correctly and all the taxes are filed appropriately for the trust assets. But anyone over the age of 18, competent, no felony convictions, can be a trustor. Those are the same qualifications as for an executor of a will. I currently have a probate, and there is a 20-year-old executing as executor for his father's estate because he's over the age of 18 and he wanted to manage it for himself and his siblings. So we're monitoring him closely to make sure he distributes everything appropriately and pays all the final taxes. But generally, a trustor, they can hire an accountant to manage the tax aspects of a trust. They can hire investment advisors to help them manage the investments. If they need to sell some real estate, they hire a realtor to handle that aspect for them. So they're not doing everything just themselves. They can hire professionals to help them with that. All right.
Thank you.
Very good.
Yep. Okay. Anything else before we move to the next slide? Okay, let's move to the next slide.
Okay, here we go. So revocable and irrevocable trusts. This is just a summary of, we've talked about some of this. With a revocable trust, again, you create a trust during your lifetime for yourself. You're the first level trustee, you're the first level beneficiary, and you can put assets into a trust, take them out. The trust property in a revocable trust is still considered yours. And so you don't have to have a separate tax return filed for that trust. It's handled under your 1040. You could even cancel or terminate a trust at any time if it no longer meets your needs. For example, I often have clients who are in their 70s and 80s, and when they were younger and they had young children, they created a trust and they put their house in the trust and maybe a vacation home and some other assets into the trust. And then as they retired and tried to simplify their life, they sold off certain assets, maybe gave children gifts ahead of time, and they don't need the trust any longer. It no longer meets their needs, so they can terminate the trust. Revocable trust, again, they're taxed as part of your state. And again, the threshold for estate tax in Washington state is 2.193 million. So anything under that threshold is not taxed at all. Federal estate tax starts at 13.61 million. With a revocable trust, you have complete control of the assets. You can add and take away assets from the trust at any time. And they're not protected from lawsuits or creditors because the assets are still considered yours. With a revocable trust, the IRS doesn't distinguish between assets that you held in trust or not. It's all your assets because you have control over them. You can take them out. With an irrevocable trust, It's not as flexible because once you put an asset into the trust, you no longer own that. The trust owns the property and you cannot take it out. It cannot be altered or terminated by the trustor after the agreement is executed. One of the benefits, however, is that you don't pay estate tax on property in an irrevocable trust because you might have paid some gift tax or transfer tax at the time you transfer the asset into the trust. For example, if you put your home into an irrevocable trust, you would pay excise tax on that transfer at the time of transfer. And then later, there's no estate tax to be paid and there's no excise tax because it's held in trust. You might want to do that if you have somebody who you want to have a home, but they might not be able to pay for a home on their own, so you're gifting it to them for their lifetime. You can do a lifetime gift within a trust. With an irrevocable trust, you have less control because you cannot remove property from the trust, nor can you change the terms of the trust. It's pretty much set in stone. However, property within an irrevocable trust, since it's not considered your asset any longer, it's protected from all of your creditors. And while property is in a trust, either a revocable or irrevocable trust, creditors cannot access that as easily. But with an irrevocable trust, it's rock solid. No creditors can access that. Once a beneficiary receives their distribution from the trust, it's no longer protected, but while it's in the trust, it is protected. Any questions about that, the summary between the revocable and irrevocable trusts?
Yes, there is a question from Gustavo.
Okay.
So just to confirm, in case of irrevocable trust, so if I
Yes.
put a property like a real estate, then I cannot sell that anymore, right?
Well, you can, if you sell that property, whatever proceeds you have of that, if you're the trustee, if you create an irrevocable trust with yourself as trustee, the trustee can manage the property within the trust. But because it belongs to the trust, if you sell that property, the proceeds have to stay in the trust. And you might want to sell one property, then purchase a different property, but they're all going to be in the name of the trust.
Ah, I see.
So
Okay,
you can set the parameters of what the trustor has. It's then with irrevocable trusts, I think the main point is you cannot take assets out and just keep them. They're no longer yours. But with any property, with a trust, the goal is to create enough flexibility within the terms of the trust. You give the trustor the authority to grow the property within the trust. So if you have a broker account within the name of that irrevocable trust, and the broker says, hey, I recommend that you sell certain stock and purchase other stock, the trust will sell the property and the trust buys the new property. It never goes back into your name, but the trustee can manage it so it'll grow. Because sometimes if a company is doing poorly, you may want to, sell the stock and buy something different. So you have a little.
But then how does the taxes in this case work?
The trust pays taxes on capital gains within the trust, just like a person would pay capital gains tax whenever they sell something. So you'd have a separate EIN number for the trust if it's irrevocable.
Got it. Thank you.
Yeah. Okay, are we ready for the next slide?
Yes, let's move to the next one.
Moving right along. So testamentary trust. So we're going to go a little deeper into this. Again, a testamentary trust is created in a will. It becomes a death effective upon the death of the person making the will. Actually, not the descendant, it'd be the decedent. Commonly used to protect, conserve, and transfer wealth to the next generation. One of the benefits of a testamentary trust is it can be conditional. So if you say, I want my assets to go to my children, however, if they're under the age of 25, I don't want them to have complete control over the assets I'm giving them. It's going to be held in trust for them. And so the trustee that you appoint for that trust for say minor beneficiaries, they would use the assets in the trust for the health, education, maintenance, and support of the trustee or the beneficiaries, but they also want to grow the trust as well and have it grow. So when the trust ends, there's enough funds for the beneficiary once they're of age, because you set the parameters for the trust. The trust assets are administered by the trustee, and they make distributions to designated beneficiaries according to the provisions of a will. Sometimes with wills that I draft, my clients say, well, I don't want to keep all the trust assets in trust for my beneficiaries until they're 25. I want to give them a distribution when they're 21, a distribution when they're 23, and the remainder of the assets when they're 25. So they get some experience with handling assets on their own. The trustor has a substantial control over the estate distribution. However, they must distribute the assets as per the parameters that you've set in the trust. And it can be used to achieve savings in the future. So when you have assets held in a trust, there's any capital gains aren't taxed until there's a distribution. So if you have several $100,000 in trust for a beneficiary, that beneficiary isn't taxed on the entirety of their inheritance. They're taxed only when they take a withdrawal from the trust, for example. And you can change or cancel any testamentary trust by amending or revoking your will. So you change it as your needs change. Any questions about that?
Okay. Moving to the next slide.
All right. Okay. Factors to consider when creating a trust. Your personal situation, including age, health, and financial status. If your estate is well under the threshold for estate tax, you may not need a trust. Oftentimes, my clients who don't have an estate over 2.193 million, they still want a trust because maybe they inherited a property in a different state. I had a client who created a revocable living trust because she had a home here in Washington State and she inherited her mother's condo in Florida. And when her mother died, she had to probate her estate in Florida. So she didn't want her children to have to go through that with her assets. So she put everything into revocable trust. So while she's alive, she could sell or do whatever she needed to do with the assets. And then when she died, it stayed in trust for her children and the next generation. You need to consider the amount and type of property you want to place into trust, your family relationships and their financial circumstances. Sometimes family want to create education trusts for certain, like nieces and nephews or grandchildren, even their own children, and give them a heads up for their life so they don't have a lot of debt when they become adults. You get to set the duration of the trust. You create, if you want it for the lifetime of the beneficiary or until they're a certain age, you get to set that up yourself. You need to look at your financial data, your tax situation, your debts and obligations, whether you want to set up a trust. Certain beneficiaries have special needs. Some of my clients have children who are disabled and maybe they receive government benefits. So you can set up what's called a supplemental needs trust, either within a trust or standalone. So the assets held in the trust are not considered an asset, so they wouldn't lose government benefits. For instance, someone who receives SSI cannot have over $2,000 in assets. And you can put money into a trust, and so the trustor would then pay directly to a provider for benefits for that disabled beneficiary, and it's not considered an asset. You can pay for vacations for them, you can pay for anything that they don't receive benefits for, and it's not considered an asset and they won't lose their benefits. You create the guidelines for the trust administration. You create the purpose of the trust and its goals. Like I said before, we mentioned that sometimes people set up a pet trust in their will for care of animals. And I've set up pet trusts for parrots. Sometimes they live well into their 70s or 80s, for horses and other livestock, and for cats and dogs and even bunnies. I've done one for a rabbit before. Conditions for receiving the trust assets. You can say they're specifically for education, or they're going to be used for health, education, maintenance, and support. So much like parents provide for their children, if you were to die before your children become of age, the trustee would step into the role of providing for their financial care. And they may turn 16 or 18 and say, hey, I want a car. I want to have this $65,000 car. And you say, well, no, we're not going to get you that. We're going to get you something less expensive, something a little older, a little bit more safe, and they can manage it for them. And so the beneficiary can ask for what they need, but the trustor has discretion whether to grant that to them within the bounds of what you've set as your parameters for that trust. You want to also consider what type of trust you want. Do you want it to be revocable? Do you want it to be irrevocable? Do you want to set up the trust as part of your will, which means you don't fund it until you die? And you can look at different alternatives for asset distribution. Some people want to avoid probate at all cost, and so they might have a trust for some of their assets, and they might have beneficiary designations on some of their other assets. And so you can figure out how you want to distribute your estate. It doesn't all have to be within a will or a trust. There's other alternatives as well. Any questions so far?
I have a question.
Okay.
So, my question is like, just to comparing like a trust with a company, right?
Okay.
Like, what about if instead of, I open a trust, I open a company and I put my assets under the company?
Okay. So if you were to create like an LLC, LLCs are generally for assets that create income. So if you have like rental properties, et cetera, you can put them into an LLC, but you don't want to put your private residence into an LLC unless it's income generating. You don't want to trigger the mortgage company a payback. So they sometimes, if you put your house into an LLC, they say, okay, you need to pay off the mortgage because you no longer meet the criteria that we set for this mortgage. So generally LLCs are for income generating properties, which works well if you have rentals.
Sure, but what about if I don't have a mortgage, for example?
Well, you don't necessarily want to put your home into an LLC because the LLC doesn't set guidelines for how it's going to be sold or distributed to your beneficiaries, unlike a will or a trust would.
No, and that's my question. Like, I could form a company. I don't know if it would be a LLC or not, but couldn't I form a company, put all my assets under the company, and I'm just, for example, the president of the company? But when I die, I can assign my son to be the president of the company. Would that be
but it
an
doesn't,
option?
it doesn't set out guidelines for how your son is to distribute the assets to your other beneficiaries. Maybe you have another son and a daughter and nieces and other grandchildren, and your son gets complete control over the company, and maybe he says, no, I don't want to distribute anything right now. And then they don't receive their inheritance. So I think companies are better if you have a business and maybe you want to put the family business into an LLC or a corporation, a limited liability company, for example, and you can.
Yeah, but I don't think
run. But when you put assets into the company, you don't create the articles and bylaws, articles of incorporation and bylaws for company don't have the same distribution language that trusts and wills have, because the purpose of a trust is to keep the assets for the beneficiaries, not for shareholders, for example.
Yeah, but in my case, it would be the same, right? Because if the beneficiary is, for example, my son.
Well, if you have
and my son will be the shareholder. In the end, he's the shareholder of my assets. No, I don't know. I find a little confusing your answer. I'm sorry, So I'm just trying to understand.
I don't do enough. I don't do incorporations. So I think if you had a business, a family business, and you wanted to list your son as the successor manager of your business, you could do that. But it's not as conducive to distributing your assets when you die as a will or trust, because a trust would say, upon my death, I give these assets to these various people, and it's liquid. Your assets are liquidated. With a business, it's supposed that the business is going to carry on until you end the business when it no longer meets your purpose. So I guess you could. I don't do business law, so I don't know if all of your
I was
questions.
just curious to know in terms of taxes, if would you
Well,
know?
businesses pay taxes at different rates than individuals.
Mm-hmm.
But that would be probably a question for an accountant who deals with business law, perhaps.
Makes sense. Yeah, thank you.
You're welcome. Because if you have a business, you don't pay a state tax on it because it's a business, not an estate. That is a very good question, and I just don't know the answer to that, but whether one is more beneficial than the other. Okay. Any other questions?
Okay. Moving on.
Okay. So the longevity of a trust. When you're trying to decide how long to keep a trust open, you look at what the purpose of the trust is. For example, a trust may end when the youngest child turns 18, 21, or 25. There's also a law against perpetuity. So usually a trust won't last longer than a lifetime plus 21 years. So anyone who's alive at the time you create the trust, it can last for their lifetime plus 21 years in general. They do have some other a little bit more complicated types of trusts out there, but generally for my clients in my practice, they talk about wanting it to last for their beneficiaries. They say, I want it to last for my children until they're of age, and then when they die, they or when they turn 18 or 21 or 25, they get it outright. And there's some situations when you have a trust set up for someone with a disability, or maybe they have an addiction or some other problem where you don't think that they're financially able to handle their assets, and it would just be for their lifetime. And then when they pass away, you determine who within the trust language, who's going to be the successor beneficiary of the trust. So most of the trusts I create, like I said, they're not created for more than a lifetime plus 21 years. But you do get to set the parameters of your trust. Some of my clients, once their kids turn 25, then they want to change the terms of the trust. So they don't need a trust for minor beneficiaries. They want to just end it when their children or maybe grandchildren, they can go to the next level, turn a certain age. But oftentimes trust is end when somebody passes away, and then once everything is distributed, the trust ends. It's met his purpose. Any questions about that?
Okay, next slide.
Okay, the duties and obligation of trustees. So we've talked about this a little bit. Every state has a statute regarding trustees' fiduciary duties. They have to act in accordance with the express terms of the trust as you created it. They have to be impartial, administering the trust for the benefit of all the trust beneficiaries, not favoring any one beneficiary over another. They have to have reasonable care and skill when administering the trust, considering both maintaining and investing the trust assets while using them for the health, education, maintenance, and support of the beneficiaries. They have to maintain accounts and records of the trust. So if ever a beneficiary wants to see an accounting of the trust assets, or maybe review the tax records, you have to provide those as a trustee. They perform taxpayer duties such as filing the tax returns for the trust and paying required taxes. Although most trustees don't file the return without the help of an accountant. It's very important to use different professionals to help you in your role as trustee. And when you do use the expertise of, say, an accountant, and something is filed incorrectly, you're not personally liable because you relied on the knowledge of that accountant to do the job. And you administer the trust property only for the designated beneficiaries, and you cannot use a trust principal or income for your own benefit. For instance, you cannot decide to invest assets from the trust in your own business, because that would be an abuse of your trust duties, and that would be a conflict of interest. Any questions about that?
Okay. Let's move to the next one.
Okay, choosing a trustee. You want to pick a trustee who's competent and has experience in managing business or financial matters, and also someone who's available and willing to serve as trustee. It's always a good idea to definitely ask somebody if they're willing to be your successor trustee. For instance, if you have a revocable living trust and you're the first level trustee and you want to decide if you want to appoint one of your children as a successor trustee, or perhaps choose a professional trust management company to do that for you, you can look at that. Individuals and corporations, or a combination of both, can be the trustee. Trust departments of a bank may offer specifically trained trust managers. And one of the benefits of having a professional trustee as opposed to a family member is if one of the trustees, individuals working for that company, retires or passes on, then they have someone else to fill in from that trust company. Although if you have a smaller estate, you may choose to use a relative, a family friend, or a business associate to manage the trust for you, because they don't generally charge as high a fee. But most trust documents that I draft, you provide a reasonable fee for their services because it is a job that they have to do. Any questions for that section?
I do have a question on this one, Carolyn.
Oh, okay.
Okay, when you say professionals can be the trustee for, yeah. So you mentioned the fee as well, right? We have to pay them for this service. How is this fee negotiated? Like we set this.
Right. Yeah. Oftentimes with the trust company, they set their fees and they say, these are my fees. Much like when you go to an accountant to have your taxes done, they say, okay, this is my rate. This is how much it's going to cost. Some trust departments take a yearly fee. They don't generally take a percentage. They take a fee for jobs that they do. If they file taxes for the trust, they will then send an invoice to the trustee, then the trustee will pay that. But if a trustee is the professional trust department, they would send out notices to the beneficiaries yearly about what their fees are and what they're taking out of the trust to pay themselves.
And can the fee go up without approving with the beneficiaries, or what's the rule?
Generally, if they have an increase in fees, much like if your bank ever increases their fee for like withdrawals, etc., at your bank, they will let you know. They have to inform you of that because they have the obligation of being completely transparent with all the trust assets and expenses.
What would be the fees? You said it's not a percentage, right?
It's not a percentage. So, for instance, if I had a client who managed a trust for a family member, maybe someone who's disabled, they say, okay, I'm going to create a list of all the time I spent drafting and working with accountants and managing the assets and making withdrawals and deposits, and my fee is hourly. Maybe they say I'm going to charge like $35 an hour, and then they create an invoice for that. But some trust departments have a yearly fee, or some of them have a monthly fee, but they will let you know that.
Okay.
And is there a concern that we should know upfront about abuse of their power over this, even though they will notify this and that, but could they exploit the trust?
If you have any concerns about them exploiting the funds and using it inappropriately, you can seek to have them removed as trustee.
Got it.
But that's why it's a beneficiaries. You want to actually request an accounting every year and make sure that they're paying all the taxes timely and they're not using the funds inappropriately.
So the beneficiaries can request the trustee to be replaced.
Yes, they can. And if
Okay.
necessary, the court will get involved.
Okay.
Most trust documents, they have language in the trust for just that. If you want to have a trustee removed, the beneficiaries all have to agree on the removal, or maybe the court gets involved. If there's like minor beneficiaries who don't have much of a voice and they don't really know what's going on, they say, okay, this trustee has sticky fingers, and so we're going to have him withdrawn, and we're going to, sue him for damages, for example.
Mm-hmm. Okay. Thank you.
So, and every state, again, has a statute regarding trust duties. And so if they abuse those duties, they can be held accountable under the courts.
Makes sense. Okay. Anything else for this slide? Okay. Let's move to the next one.
All right. Okay. And special needs trust. We talked about this a little bit in different, and bypass trust and a pet trust. So a supplemental needs trust is a trust established for those who might receive government benefits, preventing disqualification from them. Sometimes you don't want to penalize somebody who's disabled from receiving an inheritance, because that might raise their asset level over $2,000 a month, which is a very low asset level. And so assets can be put into trust for that person. The assets held in a supplemental needs trust are not considered to be owned by the beneficiary. They're owned by the trust for the benefit of the beneficiary, and the trustee then controls the assets and provides funds for expenses and luxuries that beneficiary may not otherwise be able to afford. And if they did not have a supplemental needs trust as an option, they would then maybe lose their benefits if they received an inheritance or maybe a financial gift. And sometimes supplemental needs trust can be used if someone receives a settlement for a personal injury. Maybe they were injured and can no longer work on the job, and they receive millions of dollars in a settlement, and it can be held in trust for them so they don't lose their government benefits. A bypass trust is a trust that's created in a will, so it's a form of testamentary trust. And it enables you to be a little creative and avoid estate tax. So let's say your estate is over the threshold of 2.193 million when you die, and your spouse can put the amount that's over that threshold into a bypass trust. And they assign that trust to be used for their beneficiaries when they die. So they avoid taxation on that. And it limits the amount of estate tax payable on the death of the second spouse, because the bypass trust assets are an irrevocable trust for the beneficiaries of the first decedent to pass away, the first spouse to pass away. I hope I explained that correctly, but a bypass trust is a very useful way to avoid estate tax. And with a bypass trust in the trust and in the wills that I create, you have a 9-month period to decide whether you want to put funds into a bypass trust when the first spouse passes away, because it really depends on the value of your estate when you die. And so right now we're accumulating assets, but then once we're older and we retire and we start to spend down our assets, we may not have the same amount of funds. And so a bypass trust may not be needed, even though at this point in our life, we think it would be. And also estate tax thresholds tend to change over time. Right now in Washington State, the threshold is 2.193 million, but it could go up. Federal estate tax is now 13.61 million. It goes up a bit every year. So you can be very flexible with putting language in your will for a bypass trust to be used if needed. It's a contingent type of trust. You can also create a pet trust to leave money for the care of pets that survive you. And you can have a truster listed, or maybe your personal representative, executor of your will can say, well, I'm going to pick somebody later to care for my pets. And at that time, I will then give them the money that was set aside in the will for the pets. So you can also be a little creative with that, because our pets often don't outlive us. So you don't know what animal you have at the time of your death right now, because our dogs tend to live no more than 15 years at most. So we don't really know which animal we're going to have when we die. But you can say that any pet I have at the time of my death will receive this money. Any questions about that? What defines the laws, taxes that apply to a trust? So trusts are, if they're revocable trusts, they're part of your estate when you die, and so federal estate tax applies. Again, the federal estate tax is $13.61 million starting in 2024. It's going to go up every year generally. The state of Washington, the threshold for estate tax is $2.193 million. There's also gift tax, and you have annual and lifetime gift tax rates. For instance, you can give any individual $18,000 a year with no gift tax. Anything over and above that is taxable. And you also have an annual and a lifetime tax as well, threshold. So oftentimes you can put assets into a trust, and then once the beneficiary receives that later, they would only then pay taxes on the capital gains. But generally, if you have trust as your estate, the estate pays the estate tax, not the beneficiary. So if you have an estate under 2.193 million in Washington state, there is no estate tax, and you're good with that. If you have anything over that, you can be very creative with how you're going to transfer your assets to your beneficiaries. Some of it could go by beneficiary designation. Some of it can be held in trust. So you can be very flexible with that. Any questions?
Yes, there is a question from Luciano. Let me just read the question. What defines the law, taxes, etc., that apply to a trust? The state in which it was established?
Yeah, it depends on the state and that it was established. It depends on whether the trust is revocable or irrevocable. So when you create an irrevocable trust and you transfer assets into the trust, you pay taxes on that transfer at the time you create the trust. And then when your beneficiaries receive assets from an irrevocable trust, they only pay taxes on anything out of the trust that has a capital gain. If there's a loss, you may not pay taxes on it. But it depends on the state. It depends on the federal tax at the time that they withdraw funds from the trust as well. It also depends on what type of assets you have. Stocks and bonds, their values change rapidly. Real estate, not so much. And it depends on when you put assets into the trust and when they're taken out of the trust as well. But mostly with a irrevocable trust, your trustee is going to pay taxes yearly on the trust gains. So those are taken care of. If you have a revocable trust, it's just part of your own estate, and you pay your 1040 taxes on gains and losses, or gains actually, and you get credits for the losses every year. So I can't give you a precise answer because it really depends on what type of assets you have in the trust.
Okay. Anything else on this topic?
I also have a separate document with more detail on taxation that Mercio can provide to you at the end of the presentation, if you like.
Yep. I'll share with the audience. Okay, let's move to the next slide, which is our last one, Q&A.
We're moving quickly through this. Yeah.
Yeah.
Okay. So any other questions?
So Carolyn, we have talked about there's some discussion about having a business holding
Yes.
assets, and so I think you know, for my family here, there's always a concern on how can we protect the assets. We own investment properties.
Okay.
So it's protecting the assets and making sure that, I think everybody here is worried about taxation too, right? So it's like, those are the main factors for my family. Like, how do we properly protect the assets, and how do we properly mitigate the taxation that's going to happen for the capital gains?
Okay, so if you wanted to, like if you have investment properties in an LLC, they're income generating properties, you can put LLCs into a trust if you want. If you wanted to put them into like an irrevocable trust, the benefit of that would be that you pay excise tax on the transfer of the assets into the trust at today's rate, which may be lower than the rate of the excise tax when you pass away. Because taxes tend to go up, not down. So that's a way to do it. But by having them in an LLC, it does protect you from liability. So that's another good thing about LLCs. A lot of my clients want to put their LLCs into their trust. So when they die, the trustor can manage the LLC. Because they may be the governor of their LLC. And they don't necessarily have a backup. Maybe their children are too young to manage it at this point. So they say, if I die before my children come of age, I want the trustor to handle it for me. So by putting it into a trust, then they don't have to worry about opening a probate and having to figure out how to maybe dismantle the LLC because their children aren't able to manage it yet if they're under the age of 18 or 21.
Yes, but if the LLC is nothing but something that's holding the investment properties,
right?
So there is nothing to be managed on that case.
Well, when you have an LLC, the LLC does have to pay taxes every year on the business.
I see what you're saying. Okay, gotcha. Yeah.
And so they have to manage it. And so the governor of the LLC or the officers of the LLC, they have to do things every year to make sure that they comply with the laws of the state where the property is located. They have to maybe pay federal taxes on the property. If they're going to sell one property and purchase another property, they have to manage that. So you may decide upon your death, you want it to be held in trust if you don't want your children to have that duty that you have managing your LLC properties.
And I remember having a conversation with someone regarding when you have, for example, health issues, right? At a later time, and there is a problem. For example, there is a large bill, so they will come after your assets first. Then they will come.
If you're going to go on Medicaid, as opposed to Medicare, there are asset limits. So if you're over the age of 65, you get Medicare automatically as a United States citizen, and that pays for medical care, hospital care, etc. But if you need to go into a memory care unit of a retirement home or something, that's out of pocket. That's nursing care, and so you have to maybe spend down your assets in order to care for or your family has to spend down your assets to care for you. In some nursing homes, they charge $8,000 to $12,000 a month for someone to stay there and to have their 24/7 care. It can be very expensive, and there's always add-ons to that. So if you're worried about spending your assets down for your care, you want to leave your assets for the next generation, you could transfer them into an irrevocable trust. And the government has a 5-year look back period. So if you transfer them, and then within 5 years you need care, you don't qualify for Medicaid for 5 years. But after that you do. And so that's a way of protecting the assets.
Yeah, that's exactly what I heard. Like you're right on the spot. Like, so it's like you don't get the government benefits because they will come after your personal assets.
You have to split everything down. Although if you're married, you can transfer assets to the non-Medicaid spouse. There's no look back period in certain states, such as Washington State, because we're a community property state. So there are ways to be creative, and they have supplemental needs trusts. Another benefit of trust is if you become incapacitated and you're, say, the trustor of your own revocable living trust for your lifetime, and you become incapacitated, there's provisions in the trust saying that if you become incapacitated, then there's a successor trustor who's going to step in and manage it for your care. And then they can maybe put it into an irrevocable trust. The most recent irrevocable trust I did was for a woman who lived down in Edmonds, and she and her husband purchased a home back in the 1970s, and now it's worth well over $1 million because it's gone up in value and it has a view of the ferries and the water. And she has 2 adult sons. She goes, I don't want to have my sons lose this investment property. I want to leave this to them. And so I want to put it into an irrevocable trust now. I do not have dementia. I don't have any issues. But if I do it now, then in 5 years, if I ever have to go into assisted living or a memory care unit, if something happens to me later, this is protected for them. So she created a trust knowing that there's a 5-year look back period, and that clock started ticking once the trust was executed.
Perfect.
So she did a risk analysis and decided she wanted to put it in trust. So if anything happened to her and they had to put her into memory care, she would qualify for medical coverage without using the trust, the house as an asset. It would be separate. Because again, an irrevocable trust, when you put assets into that irrevocable trust, they're no longer yours. They're not part of your estate. So that's good tax planning if you think you ever might need assisted living, because in this country, people tend to fall off a cliff if they need very expensive medical care and they spend down all their assets. So people can be very creative with trusts, and it's a good option to have.
Fantastic. Thank you.
Very good question. And we're getting into some complicated stuff. So it's kind of hard to answer all of them because it really depends on what kind of trust you have, what assets you have in the trust. But they are very beneficial. And long-term planning is very useful.
There is no one size fits all, right, Carolyn?
Exactly. Yeah. That's very true. Any other questions?
No.
Mercio, I think you should put Carolyn's contact information in the chat and share with everyone.
It is part of the presentation here.
Okay. Yeah.
Right. That's the correct information. Correct.
Yes.
Mm-hmm.
Hey, Carolyn, just to brush up a little bit on that topic that you mentioned for the federal state taxes 13 million, but for the
13.61 million, right?
Yeah, but for the state of Washington, it's very low.
It's 2.193.
2.193
million. Yes.
But it has been this value for a while, right, Carolyn?
It has been at 2.193 since 2018. It has not changed. We expect it to go up every year. It's the legislature needs to work that out. So I just, every January, I check and see if its numbers have gone up, and if they haven't, we plan for that. So yeah, there's a big discrepancy between state and federal at this point. It's over $10 million. That's a big difference. When I started practicing, the federal threshold for estate tax was like under $1 million, and now it's over, 13.61 million. So, and it's probably going to go up a little bit next year as well. But every state has their own threshold for estate tax. Washington State has no inheritance tax, but we do have the estate tax.
So just to confirm one thing, you know, on the irrevocable trust, you mentioned that like if I put an asset there, if I sell the proceeds, right, or if I buy another property, it goes back to that irrevocable.
Right. So when you as an individual, go ahead.
If I put let me finish my question because the questions are a little different. The question that I have is if I put a income property, what happens to the, you know, the rental that I receive? Does it need to go to the trust?
Yes, the trust will handle the rent income.
Okay, thank you.
Yes.
But the trust will be us, right? We are the owners. We are.
Well, if you put it into an irrevocable trust, you're no longer the owner. The trust is the owner. And the trust sets out the parameters of who's the beneficiary of that asset. So if you have a rental income and you have it in the name of an irrevocable trust, the trust owns the property, not you. So if ever you sell that property, or the trustor created the trust, they put a rental into the trust, and then they have a trustee who manages the property. If the trustee sells property and purchases a different property, it goes back into the trust. If there's rental income from that property, it goes back into the trust to be used as set forth in the parameters of that trust for beneficiaries.
While alive, are we the executor or trustees? Like, are we the guys that are making the decision, or we lose the decision power as well?
Well, if you create an irrevocable trust for assets, generally you can't be the trustor for that. You set somebody else as the trustor, or the government may consider that you have control and you lose the benefit of having an irrevocable trust. So if you have rental property that you want to manage yourself, you can put it into a revocable trust. So you have control over the assets. They're still considered your assets. And then you can sell property, purchase property, use the rental income for your own benefit. But if it's an irrevocable trust, I guess the main point is that the trust now owns the property, not you. And whoever you set as a trustee of that property, of that trust, manages the trust property. And if that's not you.
But then if I put on the, on the revocable one, I do understand what you're saying. But then the benefits decrease a lot, right? Like I was hoping that we could find like a midterm, like have the benefits of irrevocable one, but the proceeds of the rental not go there, so that would be nice.
Well, the rental proceeds will stay within the trust, and then it would go to the beneficiaries. Maybe you list your children as the beneficiaries of that trust, or it goes into different broker accounts to grow for them, but it's no longer your asset if you put it into an irrevocable trust. For instance, the client, go ahead.
I'm so sorry. No, you go ahead.
I said, so in the case I told you about where my client owned a home in Edmonds and put it to an irrevocable trust, she still lived there, but the home was owned now by the irrevocable trust. And so when she died, the trust stipulated that that property would either be sold if her two sons, the beneficiaries, wanted it sold, or they could keep it as an investment property. Her son, her oldest son, was the first choice trustee after she died, and then the second son was the second choice. And so they could determine if they wanted to keep it as an investment property or sell it. But once she died, her trust stipulated that the trust would end and the proceeds would then go to her children. But because it was an irrevocable trust and not her asset, she could then receive Medicaid without having that considered to be part of her estate.
Gotcha. But if you're doing the irrevocable trust, that you're losing control over your property now, the ownership is gone.
That's one of the downfalls. Not downfall. That's one of the negatives of having an irrevocable trust. You lose control. With a revocable trust, you have complete control.
So during the irrevocable trust, you pay the excise tax on that first transaction, right?
Yes.
You pay the excise tax.
Transferring it from yourself to a separate entity, right?
Yeah, gotcha. Because it's like a selling transaction, right?
Exactly. Yes.
Okay. And then when you do that with a revocable trust, do you also do that?
No, there's no excise tax when you transfer it in an irrevocable trust. I mean, a revocable trust, because the IRS still considers it to be your asset. So when you transfer your assets into a revocable trust, you have to pay a fee for the quitclaim deed, transferring it into the trust, but you don't pay excise tax. There's no tax. And the benefit is, with a revocable trust, upon your death, it becomes irrevocable for your beneficiaries. So then the assets stay in trust for them.
So it sounds, I don't know if I'm reading this right, but it sounds like the irrevocable trust is good to be done when you are older.
You could. However, you have to keep in mind that for an irrevocable trust, if you transfer assets into an irrevocable trust, there's a 5-year look back period for the government.
Yeah. No,
so if you need to have, if you need to go into assisted living right away, you're not going to get Medicaid until that 5-year term has passed. So,
no,
so you have to figure out the numbers.
My question was more like, so for us to have more control over a longer period of time, we delay that decision to a revocable trust, as long as we keep in mind that the government's going to look for 5 years. And so we need to be smart on that decision, because we kind of have to anticipate that, that 5-year period is going to be healthy. And then, you are meeting the desired goal of being protected by the irrevocable trust. I think that the thing that I'm struggling, and more people might be here too, is the fact that of losing control, complete control of our assets, right? And I understand why, because the government is giving up on taxes, right? But on the other hand, by giving up the taxes, that means you're giving up the control, right? So, and then the beneficiaries will take over after that, right? Gotcha.
Yeah, the trustee will manage it for the beneficiaries, who are oftentimes your children and grandchildren, right? So you're giving it basically, and most of my clients who do irrevocable trust are just giving it to the next generations in trust, and they're just giving up all control.
And I don't know if it's like put Mercio on the spot here, or if it's on, but like the decision that you guys did for your trust, was it like revocable, irrevocable? How do you guys thought about it? I don't know, maybe if you guys want to share or not. I don't want to.
Yeah, no. Carolyn, feel free to tell them what we did.
It was a revocable trust.
Revocable, okay.
So Mercio and Alessandra are the settlers of the trust. They create the trust. They're the first level trustees, and they're the first level beneficiaries of the trust. And when they both pass away, it becomes irrevocable for their children and grandchildren.
Oh, okay.
So they have control now, so they can put assets in, they can take them out, they can terminate the trust if they want to.
So you answered my question, that I wanted to delay this thing, right? So what you did, you created a revocable until the death. The event of death makes it irrevocable.
Yes.
Okay.
Upon the death of both settlers of a revocable trust, it becomes irrevocable for the next generation.
Okay, that's beautiful.
Yes. However, it's still part of their estate when they die. So if their estate is over 2.193 million, they'll pay taxes on the amount of the estate over that threshold. But not everyone meets that threshold. And I anticipate that the Washington state threshold for estate tax is going to rise. It's stuck right now for whatever reason. The legislature needs to just figure out how to increase that. And
Well,
I
it's
don't
good
know
for the state to forget, right? Because the
Carolyn, so let's just say I create an irrevocable trust and put myself and Alessandra as beneficiary. Is that possible?
You generally, you might have the ability to, you cannot be the trustee of the trust, but you might be able to receive certain of the income from the trust.
Yes, that's the idea. So rental properties.
You cannot be the trustee.
Yeah, so that's the idea. Put rental properties into an irrevocable trust. And then the proceeds will come to me and Alessandra. Okay.
However, when that property is sold, the proceeds stay in trust. And if you purchase another property with the proceeds, that is also part of the trust. It cannot belong to you separately.
Makes sense.
Because it's irrevocable, right?
Yeah.
And then it just goes to the next generation. So when you pass away, all the assets in an irrevocable trust are not part of your estate. So there's no estate tax.
You got it. Okay. Thank you.
Okay.
Would actually that be smarter than if you have income property?
It depends on whether you're willing to lose control over the property or not. Most people prefer revocable trusts because they may not want to keep the property. They may want that for their retirement. So they might say, I want to sell the property and live well. But if it's in the trust, that all the assets are held in trust for the next generation. So you can have some of the gains from the property, but you cannot have all the proceeds for the property go to you if it's in an irrevocable trust. Or else the IRS may consider that to be not a true irrevocable trust and start taxing it.
So I see Gustavo on the chat here is asking if the real advantage of the revocable trust is the fact that you can trigger that at death to become irrevocable, or is that right?
Yeah, and it avoids probate. It avoids probate for all the property and trust.
Okay, but you can avoid probate. Oh no, you're saying that the probate might happen if someone questions your sanity when you wrote the will, right? Because you said the will is not bulletproof for probate.
Well, I'm just saying that if you have a trust set up, generally the trust is set up and funded immediately during your lifetime, not after your death. And so it's not often questioned because generally we tend to maybe lose our faculties more towards the end of life. And so if we have a trust set up for years and years, they can't say the trust was inappropriately created 20 years ago.
No, I was saying it's the advantages of having the revocable is more like in comparison to a will, right? The will might be questioned, but the trust won't.
Right, and the will has to be probated oftentimes and it's public record, and a trust is private, so it retains your privacy.
So the two advantages that I'm seeing right now for the revocable trust is that one, you have a bulletproof will between quotes, right? Second, you can make it irrevocable when you die through an event of death, right? So you have these two factors. So now you have a super will, which is a revocable trust, and then you can pass it to an irrevocable when you die. That's it, right? Or no?
It's not really a will, but it can be. It avoids. So it's
avoids the probate. Yeah, got you.
Exactly. Good analogy there. Yeah. Any other questions?
Carolyn, I think it's worth, just wanted to raise the comment at the bottom that it says only practices in Snohomish County. Doesn't, like, we don't live in Snohomish County, but you still helped us with our will and the power of attorney, right? You did both for us, the financial power of attorney and the healthcare power of attorney, correct?
Yes. I think I should clarify that. when I do probates and I do also guardianships through ROG and MetLife, I only handle Sonoma County court cases. But with estate planning, as long as my clients are willing to work with me in Sonoma County, I can draft estate planning documents for anyone within Washington State.
Nice. Yeah, but there are some in the audience here. They are in Florida right now. Do they?
Right.
Do
They would
they
have to use an attorney in Florida because Florida has different laws than Washington State, and I'm not licensed to practice in Florida.
Gotcha.
And so you would have to check with a Florida estate planning attorney regarding their estate tax and whether they have an inheritance tax. So it would be different.
Okay. Anything else, guys? No. Carolyn, thank you very much.
No,
Yeah.
there's one question here that Luciano brought here. Like,
oh yeah.
He was
Go ahead, Amadou.
So, yeah, is regards to divorce after you start your trust. What happens?
Okay. Well, if you most trusts and wills actually also have provisions in there that if the either of the settlers of the trust, if it's a revocable trust, file for divorce, then they no longer receive the assets from the trust, and it will be divided. So I think let me start by the will. So if you have a will and you leave everything to your spouse and your spouse leaves everything to you, if not, then to your children, which is considered to be a mirror image will. And if you divorce, all the provisions in that will for your spouse are no longer valid. You can still have the will, but your spouse takes nothing under your estate. Because what a divorce does is it divides your assets. So however you do it in your divorce, you may split things 50-50, or someone may get the house and someone else may get more of other assets like retirement accounts or broker accounts. And so if you die and you never change your will, the spouse does not inherit anything from your will. With a trust, if you have a trust together, like a revocable living trust, and then you divorce, the trust would no longer be valid other than how things have been divided in your divorce, if that makes sense.
Even if you have a trigger on death to make it irrevocable, you still can split the assets right there during the divorce.
Because what a revocable trust holds assets that are still considered to be yours until you die. And so if you get divorced and then die, say 2 months later, your divorce would have handled the distribution of the assets between the two spouses. And so most likely the trust would no longer hold those. And so the whatever court order granting the dissolution decree for your marriage would govern the distribution of those assets.
Okay, cool.
Yeah. And the fact that we are moving to Florida, there is no impact to the trust, right? Because you file the trust here
Right.
and it's valid across.
If it's
right?
valid here, there's full faith and reciprocity between the states as to wills and trusts. So if you have a valid trust and a valid will in the state of Washington, it will be valid in Florida. However, people often want to update their wills and their trusts as their life changes.
Mm-hmm.
And so most likely you will ultimately update it in Florida. Maybe when, so for example, if you have in your will or your trust saying, any assets that go into our children under the age of 21 are going to be held in trust for them. And maybe your children then become 25 or 30. And you say, well, I want it to go for a little longer. I want to change the terms of the trust, or I want to set up an education trust for my grandchildren and put that in the trust as well. You can update it as your life changes. But the trust would still be valid even if you never update it again. That is correct.
Which one did you mention? Oh, sorry, go ahead.
No, go ahead, Alessandra, please.
Just a quick question on this topic. You mentioned that there was one of those that we would need to update when we get in Florida.
The powers of attorney.
The power, yes, okay.
Directed to physician. So I didn't go over powers of attorney. So one of you brought up the fact that if you ever became incapacitated, a successor trustee would step in to handle the trust. But if you don't have a trust, or you have certain assets that are held outside of the trust, if you ever become incapacitated, by having a power of attorney, you appoint an agent and successor agents to handle your finances and your healthcare decisions for you while you're incapacitated. And the powers of attorney void upon your death. And so if you move to Florida, you want to update the powers of attorney, because those that I drafted for you are specifically under Washington law, and I cannot guarantee that they would be honored in Florida.
That's right. Thank you.
But I did
Manu,
know
you had a
that
question.
trust, there are full faith and reciprocity between the states, just not necessarily for powers of attorney, because we base those on the Washington State Natural Death Act, and Florida may have completely different rules for governing powers of attorney and healthcare and HIPAA laws, etc.
Oh, that's right.
Those are governed by states, not federal law.
And if you move to another country, but you still have assets here, does the trust work?
Yes, the trust can manage your assets within the United States, just not outside the United States.
I had a question that was more on the document itself. So, for example, and I know that even for the will is kind of the same. Let's suppose that I have a will and I die, right? So how people know where the will is and how, because at that time that when I did was literally like a printed document that people needed to have access.
Right.
And then I said, like, is there like a, and I think that for the trust might be the same. So is there like a place that like any, go ahead, sorry.
So with a will, each court, superior court has a will repository where you can file the will for $20. Although a lot of my clients anticipate updating the wills over time, and so they let the executor of the will that they've appointed plus any successors, they let them know where the will is located, but they don't give them copies, because with a will, if you ever update it, you don't want to risk one of the older wills being filed inadvertently, because sometimes people change their estate distribution drastically over their lifetime. So you let your families know where you keep your will. In one of the probates I did last year, my client's brother passed away suddenly in his home, and he knew his brother had a will because they talked about it, but he couldn't find it until finally they were moving the mattress, and it was between the mattresses on his bed. So I don't recommend that, because it caused my client a lot of stress trying to find the will. But if you have a place in your home where you keep your financial documents, your tax returns and your deeds to the house and your vehicles and your financial documents, keep your will with that stuff. Let your family members know where your will is located. You do want to give the agents under the powers of attorney, if you have those drafted, to your successor agent. So if something happened to you and they needed to make decisions for you for your finances and healthcare, they know where that document is located, and you can actually send them like PDF copies of those documents. But you can put the will, some people put them in safe deposit boxes, some people have safes in their home. I have clients who are retired, like law enforcement and firemen, and they keep them in Ziploc baggies in their freezers, wherever you think it's safe, but you want to let somebody know where it's located so they don't have to dig through your house and maybe find it in your mattress or something.
But you mentioned there is something that you can do with like the judicial system, or is there like you can put it in a court or something, or is that?
Courts, you can file your will with the courts, and with a trust, you can file the trust with the auditor's office. Because you can record those.
All right. Good.
But you mentioned when we talked, Carolyn, that if no one knows that you did that, then they may not be enforced, right?
Well, oftentimes if I have a client who comes in and we can't find a will, we'll publish notice in a paper in the county where they last resided. Has anyone located a will? We're looking for a will for this decedent. Does anyone have any information about that? If you ever look at the legal section of newspapers, and now most of them are online, they have those requests all the time. Because you have to, when a family member dies and you have to probate their estate, in the courts, you have to make a good faith effort to locate a will. And oftentimes one isn't found. And so you just open it up as an administration without a will. Every state has a statute regarding the distribution of assets to beneficiaries of an estate when there is no will. It's called intestate succession.
But if you file in a court, everybody will have access to it. Like the whole United States will have no.
No, when a will is just filed when you haven't passed away, it's sealed. And so if you ever update your will, you go and you take the old one out, put the new one in there, but no one can access it until it's probated.
Okay.
Once it's probated, it becomes public record.
That's right. That's my question. Okay, great.
Yeah.
And that thing, okay, it's a silly question. I saw that show Succession, and then when the guy dies, and there was this will which was crossed by pencil.
Uh-huh.
And is that valid?
No. In Washington State, you have to have 2 witnesses, and it has to be when I present wills to the court, I have the original will. It can't be a copy of a will, and they review it to make sure it's valid, and they have the witnesses and they're correctly attestated. So the witnesses have to say, I signed this in front of the testator, and he was competent to the best of my knowledge, and he requested that we witness this will for him. And
okay, so there are safeguards. Yeah, cool.
You can't just add language. And oftentimes if people, handwrite little notes on the back of a will, obviously not at the same time it was drafted, those are not valid. So I don't think pencil marks would be valid. But with television drama, they have to create good storylines.
Yeah. No, but I wonder if someone later in life, just maybe older, and then saying, hey, I want to change this stuff, and then grab that paper and write something on it, which is...
Yeah, it's not valid. It's not valid. Yeah. They have to go through the process of redoing a will or making a codicil to the will, which is an addendum to maybe a part of the will. And they have to have it witnessed and often notarized as well, just to make sure it's valid.
Cool.
So pencil marks wouldn't work. Although if you have personal property items, not money, not real estate, you can create a separate personal property memorandum and direct who gets what. And you sign and date that and keep it with the will, and it would be considered valid.
Fantastic.
So,
this is very important.
Yeah, like jewelry, artwork, stuff like that. That's not money, not real estate, not stocks and bonds.
Great information. Really appreciate. Thank you.
Yeah. Carolyn, I have just one question that came to mind. I mean, we've done our power of attorney, right? But let's say worst case scenario, there's a car accident, the husband dies, the wife is in a coma, for example, and they don't have a power of attorney, neither for healthcare or finance. Who's responsible to make all the decisions that Mercio and I made on our power of attorney?
So if you have no successor agents under the powers of attorney, is that your question?
Let's say we didn't do a power of attorney.
You didn't do one. Okay. So if you have no power of attorney, and your husband dies and wife becomes incapacitated, someone's going to have to open a guardianship with the courts.
Oh, okay. Lots of bureaucracy and
yeah.
To make okay.
If you become long-term disabled, if you're just in a coma, the hospital is going to do everything they can to keep you alive, and they may ask your family members, if you're, let's say you're brain dead example, and your family members are going to have to make a decision. But if you need long-term care and you have to go into, say, assisted living, and you're no longer able to live on your own or make your own decisions, someone's going to have to be appointed your guardian ultimately.
Okay.
But if you have the powers of attorney, you get to decide. It is embedded in your healthcare power of attorney. If ever you become incapacitated and you need to have a guardianship, you appoint the person that you've chosen as your agent to be the guardian if it's needed.
Mm-hmm. Yeah. Oh, thank you.
You're welcome. Any other questions? These are very good questions.
Okay. Well, again, thank you very much, Carolyn.
You're very
was
welcome.
Really
Thank you
great.
for having me.
Yeah.
Yep.
Very
Yes.
enlightening. Even
Yeah.
for me, who thought that I had learned a lot on all the meetings we had prior to this, I even learned more. So thank you.
Exactly.
Very good. You're very welcome. And thank you so much for having me.
Thank you. Have a good
Thanks,
evening.
everyone.
All
Thank
right.
you.
Thank you.
Similar
Have a good
left
night.
for sharing the information with all of us and bringing Caroline in. Thank you.
Of course.
Thanks,
Our
Amanda.
pleasure. Thanks.
Caroline, have a good night. Thank you.
You
Thank you.
too. You too. Take care.
Take care. Bye.
Bye.